Good afternoon, dear colleagues and guests. Let us consider the meeting of Dissertation Council for defending a dissertation submitted by Vladislav Tubdenov for the degree of Candidate of Legal Sciences in the Specialty 12.00.07 Corporate Law, Competition Law, Energy Law on the topic The Legal Status of Oil and Gas Upstream Energy Companies open. Under the order of St. Petersburg State University as of January 18, 2018, number 218/1, I, Papandopoulos Vladimir Fedorovich, Doctor of Legal Sciences, Professor, Head of the Commercial Law Department, St. Petersburg State University, was appointed Chairperson of the Dissertation Council. And let me introduce my fellow members of the Council. Oleg Gorodov, Doctor of Legal Sciences, Professor of the Commercial Law Department, St. Petersburg State University. Salieva Rosa, Doctor of Legal Sciences, Academy of Sciences at the Republic of Tatarstan. Lyubov Shevchenko, Doctor of Legal Sciences, Moscow State Institute of International Relations, Ministry of Foreign Affairs of the Russian Federation. And Raphael Heffron, Doctor of Legal Sciences, PhD, University of Dundee, United Kingdom, is remotely with us. At first, I would like to especially note that under Federal Law number 127 as of August 23, 1996 on science and the state scientific and technical policy, St. Petersburg State University received the right to independently award scientific degrees. The corresponding order on the procedure for awarding academic degrees at St. Petersburg State University, on the basis of which we conduct our council meeting, was issued on September 1st, 2016, number 6821/1, hereinafter referred to as the order. In accordance with this order, the meeting of the Dissertation Council is considered valid if at least 2/3 of the approved participants of the Dissertation Council, but no less than 4 people, take part in its work. Our Dissertation Council consists of 5 members. Everyone is present, including 1 member online. He is provided with audio and visual contact, thus there is a quorum. I established the following rules for today's meeting of the Dissertation Council with a total duration of not more than 2 hours. Please pay attention to this. So it includes a brief report by the chairman on the main contents of the documents submitted by the applicant and their compliance with the established requirements, questions and answer session, not more than 5 minutes. Then a brief report of the applicant's scientific degree reflecting the main provision of his research within 15 minutes. Questions to the applicant based strictly on his report, no more than 2 minutes for 1 question, and candidate's answers. Speeches by the review's authors present at the meeting of the external reviews, no more than 5 minutes. And as not everyone is present here among those who submitted external reviews, I will be reading the external reviews myself. Then the chairman announces the external reviews received, those who are not present at the meeting, then speeches of all members of the Dissertation Council with reviews outlining their positions with questions and suggestions to the applicant, no more than 10 minutes for the speaker, then the speech by the chairman with his review, then applicant's answers to questions and comments of members of the Dissertation Council, no more than 15 minutes. Open discussion. speeches at the request of those present at the defense with a brief statement of their positions and or with specific questions and suggestions to the author strictly on the topic of research, no more than 5 minutes. And at the same time, all those who wish to, please register in the registration form and introduce yourself before asking. The final answers of the applicant to the questions asked, no more than 5 minutes. Speech by the scientific supervisor of the applicant, no more than 3 minutes. 5-minute discussion before an open vote to reach a conclusion on whether or not to award a degree from St. Petersburg State University to the applicant. There is no broadcasting at the time of discussion. And those who are not members of the council should leave the room. Open roll call. Counting of votes by the chairman of the Dissertation Council with the results recorded in the minutes of the meeting. The decision to award or not to award a degree of St. Petersburg State University, and the final word of the applicant, no more than 2 minutes. This is how we work today. And before proceeding to the implementation of the rules of the meeting, I recall the need to turn off mobile phones. Thank you. Thank you for understanding. I also inform you that the video and audio recording of our meeting is being conducted, as well as live broadcasting at the university website. Simultaneous translation of speeches from Russian into English or from English into Russian is being carried out. So let us proceed to the meeting, and our first paragraph is the chairman's summary report on the document submitted by the applicant. Tubdenov's dissertation submitted for the degree of candidate of legal sciences, major 12.00.07 corporate law, competition law, energy law on the topic legal status of oil and gas producing energy companies, was accepted for defense by the order of the university scientific secretary as of January 10, 2019, number 33/1. The dissertation council was approved by the order of the university scientific secretary on January 18, 2019, number 218/1, and I, dear colleagues, have represented it to you. The applicant submitted the following documents to the university scientific secretary. Application addressed to the rector of St. Petersburg State University, Professor Krobachev, on the acceptance of the dissertation for review and defense, filed September 14, 2018. Review of the scientific supervisor, Romanova Victoria, Doctor of Juridical Science, Head of the Energy Law Department at Kutafin Moscow State Law University. A list of publications from 4 papers that are the main scientific results of the dissertation. All papers are published in peer-reviewed scientific publications from the list approved by the Ministry of Education and Science of the Russian Federation. Diploma of Specialist with Honors issued by the Kutafin Moscow State Law University as of July 17, 2015, certifying that Tubdenov Vladislav mastered the program Major Jurisprudence with the qualification lawyer awarded by the decision of the State Examination Commission as of June 1, 2015. Certificate of Postgraduate Studies issued by Kutafin Moscow State Law University as of May 24, 2018, that Tubdenov Vladislav studied at the postgraduate course at Moscow State University of Law, Major Jurisprudence, and passed the candidate exams. Major 12.00.07 Corporate Law, Energy Law, History and Philosophy of Science excellent, English Language excellent, Corporate Law, Energy Law excellent. Diploma of Postgraduate Studies issued by the Kutafin Moscow State University of Law on October 8, 2018, certifying that Tubdenov Vladislav has mastered the program of postgraduate studies jurisprudence with the qualification teacher-researcher awarded by the decision of the State Examination Commission as of September 2018, hard copy and e-form of the dissertation in Russian and English. The dissertation is designed in accordance with the requirements of GOST. The dissertation is printed on a copying machine with an indication of the output data according to GOST. It should be noted that all the documents listed correspond to Clause 12 of Section 3, Representation and Defense of Dissertations, of the procedure for the award of scientific degrees in St. Petersburg State University. And thus, after this long introduction, I would like to give the floor to the applicant. I remind you, you have only 15 minutes. Thank you. Dear Chairman of the Dissertation Council, dear members of the Dissertation Council, the dissertation presented to your attention is devoted to the legal status of upstream energy companies in the oil and gas industry, and I would like to start with the following: that adequate legal support of activities of oil and gas complex upstream energy companies is directly related to the development of the power sector, the key industry in the economy of the Russian Federation. Taxes from oil and gas producers form a major share in the budget of the Russian Federation. In this regard, it is obvious that gaps and inconsistencies in the legal regulation of the activities of oil and gas upstream companies can have an adverse effect on the development of the power industry and the economy in general. The purpose of the thesis research is to develop theoretical insights into the rights and obligations of oil and gas complex upstream energy companies, the legal nature of relations arising between them, to detect legal regulation gaps, to develop proposals on unification of legal acts regulating social relations involving oil and gas complex upstream energy companies. The scientific novelty of the dissertation research is that it is the first comprehensive legal analysis of the legal status of oil and gas complex upstream energy companies as parties to private and public law relations in the history of energy law. Let me elaborate on some of the proposed provisions in more detail. First, the legal status of oil and gas complex upstream companies is a set of the rights and obligations of oil and gas upstream companies as parties to private and public law relations, as well as their liability for failure to comply with the requirements established by legislation. Oil and gas complex energy upstream companies are key subjects of private and public law relations regulated by Energy Law Acts. The key element of the substance of the legal status of oil and gas energy upstream companies is the requirement for a license to use subsoil resources for producing oil and gas. The applicant of the dissertation developed his own definition of the concept of an oil and gas complex upstream company. An oil and gas complex energy upstream company is a legal entity registered in accordance with the requirements of the Russian legislation producing oil, gas under the established procedure on the basis of a subsoil use license. To determine the specific nature of the legal status, the author proposes the following classification of such companies: by members, state share companies, foreign share companies; by area of activities, companies producing oil and gas at federal status subsoil sites, companies producing oil gas at the continental shelf of the Russian Federation, companies producing oil gas in the Arctic zone, and companies producing oil and gas abroad. By the method of conducting their activities, companies independently producing oil and gas, companies that enter into work service contracts, including operating agreements; by industry, companies that produce oil, companies that produce gas. The detected legal regulation gaps and the result of the legal analysis of foreign legislation regulating the activities of oil and gas complex allowed to conclude that it's necessary to carry out unification of rules on oil and gas complex upstream company, first of all at the national level, to improve legal regulations of social relations involving oil and gas complex upstream companies. It seems feasible to unify regulations on the legal status of these companies at the specific federal law level, establishing the fundamental principles of legal regulation of oil and gas production, a consistent conceptual framework, rights and obligations of upstream companies, provisions on contextual regulation, state regulation and control. Among these, some principles are proposed to establish in the federal law: the principle of striking a balance of interests between oil and gas complex upstream companies, government and consumers, the principle of priority of oil and gas production to meet the domestic demand for energy sources, the principle of differentiating legal framework for oil and gas production depending on the geographic location and geological characteristics of subsoil site, the principle of applying energy-saving, energy-efficient technologies and equipment that ensure environmental safety, the principle of safe operation of oil and gas production facilities, the principle of division of responsibility between parties to law relations in oil and gas production, considering the special role of hydrocarbons resources in the development of economy of the entire global community, natural specifics of these energy resources, as well as of the increasing terrorist threat. It seems reasonable to raise the issue of international legal unification of the rules governing matters of anti-terrorist protection of oil and gas production facilities. The provisions to be unified may include those relating to security standards for producing companies, material liability for the harm caused to people's life and health, property of the upstream companies, the environment due to terrorism acts for the purpose of minimizing consequences of such acts, provisions on interaction with authorized bodies of member states of the respective international treaty. The author proposes the following classification of contract involving oil and gas complex upstream companies by parties: production sharing agreements with the government represented by authorized state bodies, agreements with contracting companies performing specific works and rendering specific services depending on the state of geological process, contracts for research and evaluation hydrocarbon deposits, for exploration of hydrocarbon deposits, and contracts for development of hydrocarbon deposits depending on the contract scope, contracts for construction of wells for oil and gas production, operating contracts, oil and gas supply contracts, oil and gas storage contract. The research revealed that the current legal regulation lacks differentiation between the legal status of oil and gas sector upstream companies that produce oil and gas themselves and those entering into operating agreements under which the operator company develops a deposit of crude hydrocarbons, producers or stores oil and gas for a fee. The differentiation of the legal status, including in terms of administrative liability for failure to comply with the subsoil use rules, industrial safety rules, and assignment of responsibility on the operator company contracted by the subsoil user under operating an agreement, will let us restore the balance of interests between the parties whose social relations in the oil and gas complex. It would appear that development of legal regulation necessitates establishment of provision on the register of operation companies contracted by subsoil user, its maintenance, the authorized state body at the federal law level. Absence of clear provisions on ground for premature termination, suspension, restriction of the right to use subsoil resources increase the risks the disputes between oil and gas complex upstream companies and authorized state bodies. Pursuant to Article 20, Part 2 of the Russian subsoil law, a direct threat to the life or health of the people working or living in the area of influence subsoil use related operations is one of the grounds for premature termination, suspension, restriction of the right to use subsoil resources by the licensing authority. However, this provision does not define the area of influence of operations. Therefore, to eliminate discrepancies in interpretation, the definition area of influence of operation is proposed to equate to the definition the boundary of the mining allotment. Article 20, Part 2 of the Russian subsoil law also also specifies the subsoil user failure to comply with the material license term regular violation of subsoil use regulations as ground for premature termination, suspension, restriction of the right to use subsoil resources. The law does not list material license terms criteria or define the concept of a regular violation. When disputes arise as to whether there are grounds for premature termination, suspension, or restriction to use subsoil resource, the courts in fact attempt to determine whether the license term had been violated more than once. For refinement of the legal status of oil and gas upstream companies, it seems reasonable to include the number of grounds for premature termination, suspension, restriction to use subsoil resources instead of failure to comply with the subsoil license term, failure to eliminate a duly detected violation of the right to use subsoil resources specified in the license within 1 year. Current legal regulation has a gap in terms of specifics of the legal status of energy companies that produce oil, gas in the Arctic zone of the Russian Federation, while these activities involve increased industrial and environmental risks, complicated operating conditions, high cost of hydrocarbon extraction. The core element of the content of the legal status of oil and gas upstream energy companies is the requirement to have a license for the right to use subsurface resources for oil and gas. Dear colleagues, summing up, I would like to know that the conducted research has shown that at present the issue of legal status of oil and gas complex upstream energy companies have not received comprehensive research in the science of energy law and need further scientific understanding. The report is over. Thank you for the attention. So now everybody present can ask questions, no more than 2 minutes per one question, if there are any questions. Professor Gorodov, what do you think about the energy code that can be initiated? Are you for or against the possible codification? Thank you for the question. As for the energy code, this issue is in the theory of the energy law, and some scientists say that this code is necessary to regulate the relations in the sphere of energy, but for me it's quite ambiguous, and at this moment I wouldn't stand for such a code. Unfortunately, there is no voice in the microphone. Sorry, my microphone was off. Dr. Hafren, maybe you have questions?
Yes, if I could ask a question on the license to operate of the energy companies. So could you maybe describe your views on whether there should be some type of license to operate in terms of a Russian energy company, and in terms of the community that it's operating or extracting those energy resources from?
Okay.
Thank you for the question. As for licensing, at this moment in the Russian Federation, according to the subsoil law, we do have the national licensing, and moreover, I would like to say, as for hydrocarbons, it is the state-supported licensing system, and this is what we have for oil extraction, and we have it at 3 different sites in the Russian Federation. If there are any other questions, dear colleagues, please introduce yourself first. Council Member Lyubov Shevchenko. I would like to ask the question that I have in my review. You are talking about different types of agreements that we can use in this industry, and you use the term agreement regulation. I would like a little bit more clarification on this issue, because at some point it helps us to regulate the relations in this sphere. How can you clarify on this? Thank you for the question. I would like to share the opinion of the researchers who consider agreement regulation an independent sphere of regulation between subcontractors. Does it fully work, or you should strengthen these points to more feasibly use this in the industry of oil and gas? According to, when I'm talking about the industry in peculiar, I think that it can be an impetus for the development of such regulations as the independent relation between the subjects in the industry. If there are any other questions, dear colleagues, you're welcome, please. Thank you. Professor Saliva, member of the council. Dear Vladislav Germanovich, I would like to clarify one issue. As for the energy codes, there is a discussion, and what about the special law on energy, oil and gas? Maybe we should introduce a special law, and thus we can fix the legal status of upstream companies. What do you think about this? Thank you. Thank you. I can agree with this opinion, and in one of the provisions of my dissertation I state that it should be unified at the national level for upstream companies who are involved in hydrocarbon production, and we can make it through the special law, because we don't have such practice in the Russian Federation yet, and in my dissertation I introduced the principles that can be included into this law, so I can support this opinion that a special federal law is quite necessary here. So, any more questions, dear colleagues? I think that there are no more questions, so now let me continue and stick to our agenda. And as I have promised, I would like to read out loud external reviews, and then we will turn to the reviews from the dissertation council members. We have 3 external reviews. As most of the reviews are easily accessible at the university website, and everyone who wishes to can read the reviews. I would like to read only questions, but both 3 external reviews are very positive, and the authors of all the reviews make a conclusion that the dissertation complies with the requirements that we have in St. Petersburg State University, and thus the conclusion is that Vladislav Germanovich is to be awarded a degree of Candidate of Legal Sciences in the specialty 12.00.07 Corporate Law, Competition Law and Energy Law. And now let me just read some critical points and questions. The first review from Milgonov Vitaly, professor at the Department of Energy Law at Gubkin State University of Oil and Gas, candidate of legal scientist, associate professor. After the positive part, the author says that the review is very creative, but still there are some provisions that need some clarification. The thesis submitted is scientific qualified, and The author states that it is expedient to establish a special legal regime for oil and gas entities in the Arctic zone, including provisions on the methods and procedure for stimulating the activities of energy-producing companies in the Arctic zone, as well as provisions, but still there are no legal mechanisms through which such a special legal regime can be established, are not disclosed. And the second question is that the author would like to understand the author's position on the issue of what kind of experience of positive legal regulation of relations on oil and gas production in Kazakhstan, as well as in other countries considered in the dissertation, can be used in the Russian Federation. The next review is positive as well, is from the Vice Deputy on cooperation with public authorities at Rosneft, Moscow, Yevgeny, candidate of legal sciences. He also has some questions, and still some conclusions are to be further discussed. And first of all, the author proposes to introduce into the legal model of regulation of the register of operators companies that have concluded an agreement with the companies that use the subsoil resources. And we would like to clarify the author's position on the procedure for maintaining such a register and which state body should be authorized to maintain such a register. Is this proposal not an additional administrative barrier for oil and gas companies? Second question is the following. Noting the need to introduce a special regime for oil and gas companies in the Arctic zone, the author should clarify the possible ways and procedure for stimulating the activities of energy-producing companies in the Arctic zone of the Russian Federation. And I would like to mention that some questions overlap each other. You can answer it simultaneously. And the third positive review was from the member of the International Lawyers Society. After the positive part of the review, he mentions that it is necessary to answer the following questions. There are two of them. First of all, the author considers the result of the analysis of the norms of the legislation of foreign countries, Great Britain, Kazakhstan, Norway, and established the foreign legislation contains a considerable number of special norms which establish the peculiarities of the legal status of the companies which produce oil and gas. The author should specify which norms of the foreign legislation should be taken into account for further development in the Russian Federation. And further on, question number 2, in the provision 6 proposed for defense, the author also makes a proposal to enshrine at the level of federal law the provisions on the registers of operators companies that have concluded an agreement with subsoil users, the order of its maintenance, the authorized state body. In this connection, I would like to clarify the author's position on what advantages this proposal will bring for the legal regulation of the oil and gas industry's energy-producing companies. So these are the questions from the external reviews. And further on, I would like to give the floor to the Dissertation Council members and their reviews, and later on you will answer all the questions simultaneously. Now I would like to give the floor to member of the Dissertation Council, Gorodov Oleg. Thank you. So I would like to start with the point that the dissertation work is of acute importance, and I would like to outline that It is due to many factors, and first of all, the necessity of professional legal assessment and further theoretical development of legal mechanisms that can develop the regulations in the industry of oil and gas. This is the dissertation research. It is very relevant and interesting in itself from the scientific point of view, because due to many different scarce research points, still it is not very deeply studied. And this influences the legislation practice in the Russian Federation, and thus it allows us to say that the author has very timely referred to this issue in his dissertation research. Further on, I analyzed the contents of the dissertation that has introduction and 3 chapters, and I would like to highlight the positive sides of the dissertation that are present in the work, the novelty and the methodological independence of the dissertation, the independent arguments in the conclusions and in chapters, and it shows the personal involvement of the applicant in his own work, and so on and so forth. In the first part of my review, I give the general characteristics of the dissertation and the positive parts, and you can read my review at the university website. It is publicly accessed, and thus, as any composition that is part of creative activity, the dissertation research still have some arguments to discuss and ambiguous issues. I would like to highlight that there are 3 of them. First of all, the author relies on the thesis that in the doctrine of energy law it is noted that private legal relations in the field of energy are regulated first of all by the Civil Code of the Russian Federation. The features of contractual regulation in certain industries are fixed in special federal laws. For example, federal law on electric power industry, the federal law on gas supply, and it seems that the existence of special laws is not the main prerequisite for the formation of a comprehensive industry legislation. And I would like to mention, and I would like to clarify the issue of comprehensiveness, like it is highlighted in the dissertation, or with the Professor Reicher, who is the forefather of comprehensive law. And thus I think you should clarify your position on what you understand under comprehensive. That's my first point. Secondly, the provisions 1 and 4 submitted for defense are not new, in my opinion, and everything that the author says about the oil and gas upstream companies will be fair and applicable to companies engaged in the extraction of minerals other than oil and gas, for example, and applicable to the companies who are not engaged in producing and extraction. So this is quite general. Third, it's quite interesting that the author still is very familiar with the oil and gas terminology. In some points, there are trivial statements. For example, that he writes that in the oil and gas complex, production plays a crucial role in the technological chain, because without it, the subsequent processing, storage, and transportation, and ultimately sales of products is impossible. But I think it is clear, even for a child, because before you process and transport and sale production, first you need to extract it from the subsoil. But still, these shortcomings are of a private nature, and they do not reduce the overall positive assessment made by the author of the work. And the dissertation of Vladislav Tubdenov on the topic legal status of oil and gas upstream energy companies complies with the basic requirements established by the order on the awarding degrees in St. Petersburg State University, and Mr. Tubdenov deserves to be awarded the degree of candidate of legal sciences in the specialty 12.00.07 corporate law, competition law, energy law. Clause 11 of the mentioned order is not violated by the applicant. Thank you for the attention. Thank you. You're very strict but still fair. So let us move on, and I would like to give the floor to our next member of the Dissertation Council, Rosa Saliva. Please, you're welcome. Thank you. Thank you for giving me the floor, and I would like to agree with my colleagues that definitely our applicant has chosen a very topical issue to research, and still there is specifics of the certain relations that are studied by the applicant, and the specifics of the legal regulation of such relations, and it does exist, and it is quite obvious that nowadays there are not so many research works published, and thus it is the day when it is necessary to analyze the scope of regulations and norms and documents that regulate this very complex process, starting with extraction, production, and transportation, and thus there is so much done, but still there is no one comprehensive system, and thus I guess it is necessary for legal specialists to take part in this, and to study the scope of all documents, systemize them, and implement new ideas in the sphere of this regulation and in this industry, and regulate on the basis of the theoretical frameworks. And the very start of it is here and now in the sphere of energy law. And I would like to highlight that here we have this very comprehensive approach. It is not a one-side approach, but this is comprehensive, from the public law, from the private law, the regulation of such relations, and this specific to the industry of oil and gas. And thus I share the opinion of Oleg Alexandrovich. I would like to mention that the work is quite acute and timely written, and thus it is to be appraised. And the author has chosen the correct method of research, so he applies the methods of analyzing, comprehensive methods and methodology of this very complex approach to the assessment of the regulation studied is also present here. and thus the methods they were chosen quite correctly and formulated objective and tasks. All this allowed to obtain necessary results, and I would like to outline that the structure of work is quite logical. The material is depicted in a very structural way, showing the results of the research. And it is necessary to say that when I studied the text of the dissertation, I agreed with many points mentioned here, and as it mentioned in chapter 1 to discuss the concept of the oil and gas producing companies, the varieties of the companies, and studying the legal nature, and thus you can obtain quite useful and effective results. When you have concepts and notions, there are very few of them, but still they were introduced, and the classification given that allows us to get the conclusions and various classifications with various bases. In chapter number 2, the author examines the content of the legal status of oil and gas companies as subjects of private legal relations, and the peculiarities of the contractual regulation of relations with participation of different companies, operating companies, and thus the regulations on the legal status of both of them that the author is introducing in his work, and I guess that we should agree with that. In the 3rd chapter, the author discusses the peculiarities of the legal status of oil and gas companies as subjects of public law relations. And the conclusion of this chapter is the questions of the legal support and grounds of early termination, suspension, health issues were also discussed and introduced in this chapter on prevention of various accidents. I can appreciate this approach, and other points that were discussed, they were quite timely discussed. And as the general framework of the dissertation, I would like to mention that the author managed to reach the objective of the whole dissertation, work out some theoretical points on the upstream companies and the legal status of such companies, and at the same time he was able to introduce the proposals on the unification of the studied relations. And in general, I consider this dissertation from the positive point of view. I still would like to mention that as any research work, this dissertation is not devoid of some points to discuss. And thus I would like to highlight several points, at least 2 of them, and I would like to listen to the opinion of the applicant. First of all, it seems to be a debatable proposal set forth in paragraph 7 of the provisions submitted to defense, in which the concept of zone of influence of works is proposed to be equated with the concept of boundaries of mining allotment. This, in my opinion, it is quite obvious that it is quite debatable, and we cannot equate the concept of zone of influence of work and the mining allotment, because mining allotment is some fixed fragment of subsoil objectified at a geographical point with some legend. And the zone of influence of works, it's the influence upon the atmosphere, upon the forests, upon the internal waters, groundwaters, and the flora and fauna and the environment in general, because there are some problems connected with the neighboring territories when the groundwaters flow, because they flow from different regions beyond the boundaries of mining allotment, and the air is also circulating. Thus, in my opinion, I think we cannot equate these two concepts. And thus, if, for example, the company has built and operate field facilities that do not comply with the design documentation, and they are not built on the licensed area with deviation from field development projects, there are some cases that we know. In this case, the area of influence of the works does not coincide with the boundaries of the mining allotment. At the same time, we cannot say that these concepts are equal, and concerning this case, it is unlikely that the provision on equivalence of the concepts under consideration is applicable. Also, the environmental consequences may not coincide with the boundaries of the mining allotment. So it is to be further discussed, and I would like to listen to your opinion on the point. And in the chapter devoted to private legal relations, the dissertation discusses the separate paragraphs considered only with legal problems arising in the framework of the conclusion, execution, and termination of contracts. And does this mean that there are no such problems in other contractual relations? In this connection, it would be desirable to know the opinion of the author on the problems concerning contractual regulation of relations in connection with oil transportation through trunk pipelines, in part of change of oil quality in trunk pipelines, and introduction of oil quality banks. I would like to clarify on these points, and overall it can be concluded that the dissertation submitted for defense today by Mr. Tubdenov on the topic of legal status of oil and gas producing energy companies corresponds complies with the basic requirements established by order number 6821/1 in St. Petersburg State University, and the applicant deserves to be awarded the degree of candidate of legal sciences in the specialty 12.00.07 corporate law, competition law, energy law. Clause 11 of the said order is not violated by the applicant. Thank you, Rosa Nailevna, for your review. Especially for me, it was interesting to listen to your knowledge in the sphere of mining works. We will discuss that later. Thank you. And now I would like to give the floor to Lyubov Shevchenko. Please, you're welcome. it is very difficult to talk after Rosa Nailivna because she's always talking about mining works, and you start thinking whether this is the right specialty, the right major that we have chosen for the applicant. I won't discuss the fact that this is of vital importance, this dissertation, that this is timely and actual, not because we have formed the scope of normative regulations that are not perfect, that are contradicting each other, because we can have many different provisions in different laws. This is all to be reviewed and reorganized. It is the time for us to review the doctrine, all the points of view, because we have so many papers, so many works, because when we started our master's program, we recommended the works by Oleg Alexandrovich, by Vladimir Fedorovich, very theoretical works that are defining the peculiarities of this of the energy law as the branch of law, as the independent discipline. And now I would like to highlight the following. I read paper by Professor Sukhanov for a doctoral dissertation, and Sukhanov noted that this doctoral work was quite acute because there are no works on energy law and on contractual regulations in this sphere, and I think it is high time that we discuss, that we work. And I cannot agree with Professor Sukhanov saying that there are not so many works and monographs and dissertations and candidates' dissertations. Maybe this is his personal point of view, but still everyone present here has lots of works in this sphere, and the scientific supervisor, she herself has a lot of works, and I think it is high time that we analyze what is working for the idea of energy law as independent branch of law, and why is it too early to discuss the energy code. And I think that our applicant has chosen the right way, that it is necessary to solve all these issues step by step. First, to introduce some laws after analyzing certain spheres, then together review whether it can be included in the concept of energy law as the area, as the industry, because we are still only moving towards industry, and this is of acute importance, I guess. And I think I would like to thank everyone who is involved in solving these issues from the point of view of dissertation defense, because this is the most difficult thing. I was getting used for a long time to this energy law, to these regulations, and I understand that this is very significant work that was done. And I read this dissertation with pleasure. This is the work for the degree of candidate of legal sciences, and still it is very well structured, and the author reviews the legal status of companies in a certain industry, in oil and gas industry, upstream energy companies, legal status. My associate professor at my university and we started writing a book, and we realized how difficult it is to work in this sphere, and thus I understand that the applicant had a very difficult way on how to characterize the legal status of these legal entities, and I think he succeeded in this with his classification, and maybe later on he can extend this classification, and maybe it can be more detailed. What I liked that in chapters number 2 and number 3 he reviewed the relations of the company. For example, it was dedicated to agreements, operational agreements, well construction agreements. They were not so well studied either in practical or theoretical ways. I think I can include this in my further lectures. This is what I noted further on in chapter number 3, where he's talking about public law relations. It was also very interesting and new things for me to think about connected to licensing. And taxes. It is all clear when you talk about this in Russia, because taxes is the first thing that we pay attention to, and thus it was all quite successful. We can agree with most of the conclusions presented for defense, and thereof our main interest. I think he's a bright young man and he can continue work in this sphere, and thus he's going to pursue his teaching career. I have a very detailed review, and I have mentioned in it what provisions are to be assessed with detail, but still I would like to highlight that any work can be further on discussed, because in his work he has many more provisions that could have been submitted for defense. We only discussed 9 of them. It is okay, but still there are many more of them. I do have some notes. It can be more deeply studied in this from the point of view of energy law, concerning the peculiarities of contractual regulation, because this is in fashion now, because you cannot just list the contracts signed in different spheres, but you should review what regulation functions they have. And I think it is very difficult, because you do not have access to many of these contracts, and that's why this question was discussed very briefly. And I would like to clarify the author's opinion with regard to the legal status of energy upstream companies when decommissioning wells. It is a very difficult question for practice, and is the current legal regulation in this part sufficient, or we should develop it further on? In Regulation 8, the applicant points out to the possibility of establishing in the energy legislation such grounds for early termination, suspension, restriction of the right to use the subsurface resources as the absence of the fact of elimination of the violation of the condition on the right to use subsurface resources specified in the license within 1 year, which has been revealed in accordance with the established procedure. What is understood by the author as violation, a decision of the authorized body, a judicial act that came into force. These comments have a controversial clarifying certain positions and do not detract from the significance of the dissertation, its high evaluation. And This is a very strong work, and the author has the publications in the necessary scientific journals as the conclusion of his work. And I think that this dissertation complies with all the basic requirements established by St. Petersburg State University, deserves to be awarded the degree of candidate of legal sciences. Thank you. I try to be brief as possible. Thank you. Thank you for your review. And now I would like to give the floor to the member of the Dissertation Council, Dr. Hafren.
Thank you. So, if I could give my comments, and I will try and keep things brief. Maybe if just the other panel members turn off the microphone. So I think there's one microphone left on at the front, which I can hear the echo.
Вас хорошо слышат.
I think there's one microphone left on at the front, which I can hear the my voice. So thank you very much, and I would echo the thoughts of the other panel members in terms of the good quality of the dissertation, and also the fact that it is a very topical issue. I think a thesis that focuses on energy companies has been rarely done so far, obviously in Russia, but also in terms of colleagues in this energy law area across the world. But I think it's a very good time to focus on the law around energy companies, and I suppose particularly we are thinking about companies making their investment decisions in the energy sector. And as one or two of the panel members said before, we think of that, that law behind those investment decisions in the energy sector, and how can we enable potentially more investment for these companies and enable better rules in the energy sector. So some of the other strengths that I did like about the thesis was that it engaged in some interdisciplinary literature as well. So there was a reflection also on some of the political issues around the energy sector, and I think we could nearly all agree that in terms of energy, there is definitely an overlap between politics and law, and I think the candidate took account of this. I also thought it was a good feature in the study in terms of the geographical scope, including a very important issue in terms of the Arctic, which is important for Russia, but also important in terms of oil and gas development for several other nations in the world, and also the other comparative study taking into account the UK and Norway in particular. In any legal thesis, I always do like to see that in terms of a contribution to knowledge, that a scholar gets across a practical element of a contribution as well as a theoretical contribution. And I think in the first question and answers session and some of the comments by the other reviews, that there is the case for introducing special legislation which has been advanced by the candidate. And also the candidate has advanced their theoretical contribution. And I just highlighted in my review and I will keep things brief, and with my review being available online, I did highlight that I do think the candidate should spend a small bit more time both in the introduction and the conclusion, going more into depth about those contributions. And I think that contribution is not just in terms of Russian energy law, but I think there's a contribution there that is applicable for many other states and, you know, around the world, that this goes beyond just Russia as a case study. And I would also, I suppose, let's say, finally like to highlight that I think the author maybe needs to have add something to the discussion in talking about contractual issues or in talking about liability issues. I think there has to be a reflection overall on what some of the limitations are of the thesis. And in any piece of scholarship, there will always be some limitations. And I think particularly when we're dealing with energy companies, there is an issue of how much information is commercially sensitive for those energy companies. So we may not always get access as a research community to some of that contractual information, or particularly maybe some issues around liability. And I think the author could spend some time discussing those as general limitations of legal research and maybe how they affected some of their conclusions. And I think that by discussing some of those, let's say, commercially sensitive issues in the area, in the context of energy companies, and discussing those in the context of limitations of the research, that I think that also shows the scope for further research in future, whether that be by the candidate or potentially by future researchers in the area. So overall, like my colleagues on the council, I'd agree that the PhD or the thesis is deserving of getting the award of the PhD. So thank you very much.
Спасибо большое вам.
Thank you, Mr. Hafren. And now I would like to give the floor to our next review. This is my review, the review of the chairperson of the Dissertation Council. And I would like to remind you that the review is available at the university website. So I would like just to briefly describe the review. I think that the dissertation is a very topical issue, and this is predetermined by a number of factors, both economic and legal in nature. And as we have mentioned, it is necessary to somehow systemize the legislation in this sphere, because people who are in this sphere, they know that the legislation is very vast, is not unified, and so on and so forth. And the author himself, in his dissertation he makes his conclusions, and he unifies this legislation, and not just this legislation, not just at the level of the Russian Federation, but maybe with some application on the international level. And thus, in the sphere of energy law, there are lots of publications, but still we understand and we know this because we are working in this sphere. There is still a lot of work to be done, and still there is so much work to do in the future. And I would like so that everyone who are working in this sphere, please pay attention to theoretical part of this work. In his dissertation, Still, there are theoretical aspects, but I think it is more about the practical issues, how to organize legislation, how to organize the activities, and so on and so forth. And I would like to underline that it is necessary to somehow generalize all this information theoretically. That can be the basis for the development of legislation and the practice of its implementation. I think this should be the ground for further practical issues. I won't dwell upon the characteristic of the contents, the structure, and the conclusions that were made. I would like to highlight that the conclusions, they are connected with the issues discussed in the chapters, and they are well argumented and implemented, and thus they're valid, and we can accept them as the contribution of the author into the issue he's dealing with. I would like to be brief about the main remarks, if I can use this word, but the questions that need to be considered, there are two of them, only two questions that I have, or rather pay attention of the author. So first of all, the content of the dissertation is not limited to the issue of the legal status of oil and gas producing energy companies, because it is broader than the name, because if it were vice versa, that would have a more adverse effect, because if the name of the dissertation has the words legal status, but this is more than legal status which is discussed in the work, still this is the issue. So you should have changed the name of the dissertation or somehow reflect this in the name, maybe. One of the objectives of the dissertation stated by the author is to develop theoretical provisions on the subject of the study. I would like once again to highlight that here the main provision can be theoretical, is the author's provision number 1 on the concept and legal status of oil and gas upstream energy companies. But still here the author should have shown the correlation of such concepts as legal status as the general concept, and legal status as private concept, and how they correspond and how they manifest themselves in private and public sphere, because in the dissertation we have private and public aspects of this industry. I personally think that it is unlikely that the concept of legal status in terms of its content is reduced to a set of existing rights and obligations. Does this definition include such concepts as legal capacity? So that's the first aspect of my remark. And the second aspect, if there are any other forms of access to oil and gas production activities, such as public-private partnerships, if there are any other forms that can reflect the status of such companies, if there is no such practice, is it possible to develop it in this area? Is it appropriate for this area? And still there was nothing mentioned in the provisions submitted for the defense, but I think that these issues are relevant in the context of development of market relations and also relate to the topic of the dissertation research. And still I can say that we can conclude that the work of Vladislav Tubdenov, it is independent, it is creative in its content, it complies with the main regulations of St. Petersburg State University on the order of awarding degrees, and the applicant, Mr. Tubdenov, deserves to be awarded the degree of Candidate of Legal Sciences in the specialty 12.00.07 Corporate Law, Competition Law, Energy Law, and as everyone says, Clause 11 of the State Order is not violated by the applicant. Thank you for the attention. Now, I would like to give the floor to Vladislav Germanovich to answer all the questions asked. And can you please try make it brief, because you only have 15 minutes for that. Thank you. Dear council members, dear chairperson, external experts, thank you for the reviews, the recommendations and remarks and positive assessment of my work. Now I would like to answer the questions from the reviews. So first of all, I would like to start with the questions by Rosa Salieva. I would like to thank you for the review and recommendations. As for the questions on private law relations and the quality banks, in chapter 2 I have the classification that reflect the specifics of the companies. But still, for the purpose of dissertation, it was important for us that the industry should be within the focus of our research, but still we understand that there are various contractual issues. As for the quality bank, at the same time, it is impossible to deny the existence of legal problem arising from the conclusion and execution of other contracts with the participation companies. And as for quality banks, it is possible to support the position already expressed in the scientific and expert community, and in the Republic of Kazakhstan they do have such mechanisms. As for question number 2, the zone of influence of work and the concept of borders of mining allotment, it is understood that it can be beyond the mining allotment, and in provision for defense we can equate this as it is understood in part number 2 of Article 7 of the subsoil law, that says when determining the borders of mining allotment, the special contours of the mineral deposit, the location of the construction site and operation of underground structures, the boundaries of safe mining and blasting operations, the protection zone from the harmful effects of mining, the zone of movement of rocks, the contours of protective pillars under natural objects, buildings and co-workers are taken into account. The boundaries of mining allotment take into account the boundaries of safe mining. And the proposal is aimed at eliminating a gap in the legislation. According to Criminal Code Article 255, the violation of the rules of subsoil use can be qualified as a criminal offense. In addition, it seems inappropriate to further expand the application of such liability measure as early termination of the right to use subsurface resources as compared to the cases already provided by the law. The obligation of a subsoil user to comply with the requirements for environmental protection is stipulated by the Russian subsoil law and the administrative offenses code. At the same time, it should be taken into account that termination or suspensions of the license for the right to use subsurface resources may actually mean termination of the company's activities, and therefore the application of such a liability measure should be proportionate to the offense. Thank you very much for the review. The next question I would like to answer is the question by Lyubov Ivanovna Shevchenko. I would like to thank her for the review, for the feedback and recommendation. The question on the regulation, as I have mentioned already, concerning about the well abandonment, it is very acute for the state because lots of wells were not abandoned because they were left ownerless and they were not privatized. And after we develop the well, the companies, they do not abandon wells, they do not comply with the regulation, as according to Article 22 of the Russian subsoil law, a subsoil user is obliged to ensure the liquidation of well according to Article 26 of the law, the conservation and abandonment of mining works and other structures associated with the use of subsurface resources. In this regard, the legislative initiative on creation of liquidation funds to which users of subsurface resources would make deductions to guarantee fulfillment of obligations. And this is being reviewed right at the moment, and the companies are against this initiative because they think that this wouldn't solve the problem and would only lead to collecting of funds. So they are against the liquidation funds. And thus practice shows that the current legal regulation in this area needs to be improved, and at the same time it is necessary to take into account the opinion of all stakeholders of this process. As for question number 5, what do we say about the violation revealed in the established order? As the Ministry of Natural Resources of the Russian Federation from 2009, number 315. This procedure provides for the establishment of permanent advisory bodies under the Federal Subsurface Resource Management, the instructions of Rosprirodnadzor, and they make recommendations including the issues of notices to the subsoil user about the violations committed and the period of their elimination. Then the corresponding notification is issued, and thus the issuance of this notification can be considered as a revelation of the violation in the established order, and from this document to count 1 year for elimination. In turn, there is a possibility to contradict this decision and notification, and thus in this case we will have to turn to court for the solution of such problem. Now I would like to thank Raphael Hafren for his feedback, very valuable recommendations and additional references to research in the sphere of energy law from foreign colleagues, which Dr. Hafren has reflected in his review, in his report. And I would like to thank him for the review, and I would like to know that the presence of introduction and conclusion in the structure of the dissertation is a standard requirement for the dissertation research in the Russian Federation. And I would like also to thank Professor Hafran for the pieces of advice that Professor Hafran has highlighted in the reports, that I can restructure introduction and conclusion, and I will take that into account in my further work. Thank you a lot. As for question from Vladimir Papandupola, I would like to thank him for the positive assessment and valuable recommendations. As for the name of the dissertation and the term legal status, I would like to mention that the dissertation is devoted to the legal status of oil and gas extractive energy companies. The purpose of the dissertation research was to develop theoretical provisions on the content of the rights and obligation of oil and gas upstream energy companies, the legal nature of relations arising with their participation, identify gaps in legal regulation, formulate proposals for the unification of legal norms governing social relations with the participation of oil and gas upstream companies. With this goal in mind, the task set for the dissertation, the study was set. It seems that the subject of the dissertation research corresponds to the goals and objectives of the dissertation research. The restrictions and the different forms of companies and requirements for such companies. And thus we were able to discuss the regulations of such companies from the very establishment of these companies. As for the private and public cooperation, according to the federal law on concessional agreements, they are not part of federal law on concession agreements. And thus it seems necessary to develop this sphere, and the proposal mentioned in the review might be the subject of separate dissertation studies. It should be also noted that there is a significant scientific basis that can serve as support for further research on public-private partnerships, and in this regard I would like to know the works of Vladimir Papandopoulou on public-private partnership notion and legal forms on concession agreements. Thank you very much for your recommendation and support. I would like to thank Oleg Gorodov, and concerning the question about the legislation form, naturally the existence of special laws is itself not the main prerequisite for the formation of a comprehensive branch of legislation. It is necessary to take into account what social relations are regulated by these or those laws. The adopted special federal laws, including the law on gas supply, the use of atomic energy, the law on electric power industry, and at the same time the sources of energy law are not limited only to special federal laws regulating relations in the energy sector. As Mr. Gorodov notes in his paper Introduction to Energy Law, the energy legislation, along with the legislation of other industry accessories, is organically included in the system of energy law sources and its main type. Concerning the question on provisions 1 and 4 submitted for defense and are not new and can be applicable to other companies, I would like to say that among the goals and objectives of the dissertation study, it was not intended to be the formulation of provisions relating to activities of all companies. Whether the conclusions and recommendations made in this work to companies other than oil and gas companies will be acceptable to them may be the subject of separate legal research. Concerning the issues of anti-terrorist protection, I think it is of vital importance because it is necessary for the national level, and there is such a unification reflected in the federal law as of 21st July 2011 on safety of fuel and energy complex facilities. Now I would like to shift to the questions from the external reviews. I would like to thank Evgeny Moskov for the review and recommendations and support in the sphere of the operators register that have concluded contracts with subsoil users. I would like to clarify my position on the procedure for maintaining such a register and which state body should be authorized. For me, I think the main body should be the Ministry of Energy of the Russian Federation, and the Ministry of Energy is already keeping the register of business entities engaged in oil production since 2011, according to the law on the procedure of connection of oil production facilities to main oil pipelines in the Russian Federation. And this register is publicly accessed. The proposed register is aimed at ensuring a balance of interest of extractive companies, license holders and operations, as well as state authorities. In turn, the subsurface users can rely on the register when engaging operator companies to carry out work at a subsurface size, and the introduction of such a register will significantly simplify the tax admission of subsoil users and operators of carbohydrate fields, and it will also provide the better safety of the maintained works. As for work in the Arctic zone, stimulation of Arctic zone activities, establishment of the declared special legal regime is possible by means of acceptance of necessary normative legal acts, federal laws and subordinate normative legal acts. I would like to know that federal law on the development of the Arctic zone of the Russian Federation has not yet been adopted. It is only one norm that is devoted to the extraction of oil and gas sources. And in 2013, the federal law on amendments to Chapter 26 of the Tax Code of the Russian Federation was adopted. It includes the incentives for hydrocarbon production on the continental shelf of the Russian Federation. And the Arctic zone is not only the continental shelf, but it also includes land, territories, territorial sea, and internal waters. In this regard, it seems expedient to develop additional measures of tax, customs, and tariff incentives. It also seems expedient to raise the issue of developing provisions providing for the possibility of applying the mechanism of public-private partnerships with the participation of oil and gas producing companies. I would also like to thank Mr. Melgunov for his review and his recommendations, and the questions about the Arctic zone, it overlap. It coincides with the question of Mr. Moskov, the same concerning the question about the international experience. I would like to know that the dissertation study considered the peculiarities of the legal status of oil and gas production companies in the UK, Kazakhstan and Norway. If we talk about the borrowing of legal regulation models from foreign countries for oil and gas companies of the Russian Federation, it is necessary to take into account firstly the peculiarities of the legal system of the Russian Federation, namely that not every rule of foreign law can be used in Russia, as well as secondly the peculiarities of the domestic oil and gas industry. From the foreign experience of legal regulation, it seems expedient to pay attention to the fact that many foreign countries have adopted separate special legislative acts which fix unified provisions on the establishment and operation of oil and gas companies, provisions on the procedure of conclusion and execution of the operator's agreement, accounting of hydrocarbons production in different conditions. And I would like to also thank the external review from Vyacheslav Gusikov for the recommendation and support that he mentioned in his review, as I have grouped my questions and I have already answered most of them. And concerning the international experience and the register of operators companies, so I wouldn't like to repeat it all once again. And in conclusion, once again, I would like to thank all the members of the Dissertation Council and external experts for the reviews, for the feedback, for the recommendation, remarks, notes and questions, for the positive assessment, and I will take this all into account when I continue my further research, all these pieces of advice that I can use in the future. Thank you. Thank you. Please take a seat. Now, according to our agenda, I can give the floor to any person present, except for the members of the Dissertation Council, because they have expressed their opinion. So and now I would like to give the floor to the scientific supervisor of the applicant, Victoria Valerievna Romanova, Doctor of Legal Sciences, Head of the Department of Energy Law. Dear colleagues, dear council members, thank you for the opportunity to give a talk. I have a positive review. I think that it is very topical, this issue, and I think it was very important, and I think that it can have positive assessment and the analysis of the foreign experience in this sphere, and very interesting conclusions were made. One more feature to be noted is that Vladislav Germanovich is working at the Geological Expertise Institution, so it supported him during his preparation and work. And I think that his dissertation corresponds and complies with all the requirements, and the applicant is to be awarded the degree with major 12.00.07, competition law, energy law, corporate law. And I would like to thank all the members of the Dissertation Council and all the external experts for the recommendations, reviews and feedback. And in my turn, I would like to wish him all the best in his future scientific work. Thank you. Thank you, Victoria Valerievna. Now, I would like to turn to the discussion. The issue of whether or not to award the degree, and this is a closed discussion. So I would like to ask you all to leave us for some time. We will invite you back to this room.
Be with
Уважаемые коллеги,
Dear colleagues and guests, I continue our meeting. Please turn on the audio of the meeting. And now I raise the question of awarding a degree to an open roll call vote. I remind you that the decision of the Dissertation Council on awarding an academic degree is considered positive if more than a half, but not less than 3 members of the Dissertation Council who participated in the meeting voted for it, according to paragraph 23 of the Order of Awarding Academic Degrees in St. Petersburg State University. Thus, I ask each council member, dear Gorodov Oleg, your opinion. I vote for. Thank you. Rosa Saliva, your opinion. I vote for. Thank you. Lyubov Shevchenko, your opinion. I vote for. Thank you. Council member Rafael Hafren, your opinion.
I vote for.
спасибо.
Thank you. And as the chairperson of the meeting, I also vote for. Thus, dear colleagues and guests, I declare that from 5 people participating in the meeting of the Dissertation Council, 5 board members voted for, nobody voted against, and nobody abstained. And I declare that the decision was made to award the degree of Candidate of Legal Sciences in the specialty 12.00.07 Corporate Law, Competition Law, Energy Law to Vladislav Germanovich Tubdenov. and thus I can congratulate you with this, Vladislav Germanovich. And I would like to give you the floor for the final words of the applicant. You're welcome. Thank you, dear chairperson, dear council members. I am deeply honored that the Dissertation Council that assessed and discussed my dissertation, that it encompasses so profound scholars and scientists in the sphere of energy law. I would like to thank you for the positive assessment of my work and for the recommendations and the feedback reflected in your reviews. And I would like also to thank our colleague from abroad, Professor Heffron. Thank you for your participation. Thank you for your review and the recommendations provided. I would like to also thank the person that made a great contribution to my work, my scientific supervisor, Victoria Romanova, who followed me and who supported me throughout all my postgraduate studies, who gave me the necessary recommendations and crucial remarks. And without her, it would be impossible for me to continue with my work. And I would like also to thank my parents who supported me throughout all my way of postgraduate studies. And they are also present here and they support me, and as well as all my relatives and friends who helped me and assisted me and supported me throughout this period of studies, and I would like to thank you all. Thank you. And I would like to declare, dear colleagues, that the meeting is declared closed. Thank you all for participating. Dr. Halfran, thank you for participating. Members of the Dissertation Council and those who present, who have enough time to pay attention to this very important event. Victoria Valerievna, congratulations to you with your applicant. Thank you. Please disable the live broadcast of the meeting.